Good morning, everyone. And noting some of the participants list for today's event, also good afternoon to some. I warmly welcome you to this discussion focusing on the rule of law and the EU member states' responses to the COVID-19 pandemic, particularly its most recent second wave. My name is Paul Zubkov, and I'm Manager Europe at Democracy Reporting International. For those who may not know us, DRI is an independent, non-partisan NGO that promotes the political participation of citizens, accountability of state bodies, and the development of democratic institutions worldwide. We are headquartered in Berlin, so in Europe, but we also have country offices in such places as Tunisia and Lebanon and Pakistan and Sri Lanka and Myanmar, and even closer to home in Ukraine. For the past 2 years, together with Forum Transregional Studieren, DRI has been running a dedicated program aimed at fostering an informed and evidence-based debate on the rule of law in Europe. This reconstitution program, as it is called, includes fellowships, discussion events, and analysis of key rule of law developments across the EU. It is precisely under these auspices, with the generous support of Stiftung Mercator, that is funding this current program, that we are holding the event today. Before moving on to introduce our excellent speakers, allow me to set out a little bit of context for our discussion on the impetus for the report that we are launching. It is clear that the current pandemic has presented profound challenges for life within the European Union. This story is woven of personal and professional hardships, including for many of you who are on this call today. It is the hardship of citizens, businesses, public officials, and of course, health professionals on the front line. It is also a story of serious governance challenges, including around the rule of law, as states have sought to respond to this fluid, rapid, complicated, and often unpredictable crisis. In the years since the declaration of the global pandemic by WHO, the limitations of movement and activity that have been placed on individuals, as well as those on educational and commercial activity, have been among the most restrictive in recent European history. Unthinkable just 14 months prior. This has raised serious questions of legitimacy, proportionality, and certainty of government measures, as well as of other aspects connected with the rule of law. Notably, in this time, we have also seen another very public link between the pandemic and the rule of law that has catapulted the rule of law from a more obscure legal term, known more to us lawyers or those in the public science field, onto the front pages of the media. And here, of course, I'm thinking to the rule of law conditionality debate last year connected with the COVID-19 relief funds. Most of the action in response to the pandemic has been led by national governments, given the more limited competencies of the European Union concerning public health. This has resulted in a great diversity of approaches and restrictions and measures. And of course, given the nature of the crisis and the dilemmas it poses, including moral dilemmas as well as legal dilemmas, we should have some empathy for the challenges faced by public officials and offer some presumption of good faith. At the same time, however, we should be cognizant that we are not in the first few months of the pandemic anymore, but we are almost a year, well, more than a year down the line. And there were plenty of warnings of the second and possible further infection waves to come. So there should have been some corrective action and learning in hand. Most particularly, of course, we had the summer period, and there are justifiably high expectations, particularly from citizens. It is against this background that DRI has gathered the assessments from 35 national experts, covering all 27 member states, to look at the country's responses to the second wave of the pandemic, looking specifically at the period from October last year to February this year. And it is this analysis that has been captured in our today's released report entitled Extraordinary or Extra-Legal Responses, the Rule of Law and the COVID-19 Crisis. You can find this report on our website, and there will be, I believe, a link dropped into the chat box as well. To discuss the report and its findings, I'm extremely delighted to discuss these issues with three excellent speakers for whom we're thankful for offering their time. The first speaker is Dr. Joelle Grogan, who is a senior lecturer in law at Middlesex University London. Her primary areas of research are UK and European Union public law, with an expertise specifically on the rule of law. Her current focus is Brexit, and she is a force of nature on the legal measures taken in response to the COVID-19 crisis. She's a member of the H2020 funded Reconnect project, and she's also the creator of the Sticky Tricky Law project, which is fantastic, a little resource on Twitter, you should look it up. Joelle is also the convener of the COVID-19 and States of Emergency symposium hosted by the Verfassungsblog last year, looking at the first wave of the pandemic, and the power in the COVID-19 pandemic debate, which is currently hosted by the Verfassungsblog, which covers more than 70 countries around the world and involves more than 100 experts around the world as well. Notably, Joelle is the author of the DRI's report that is being released. Álvaro de Elera, as you may see, he's a member of the cabinet of Věra Jourová, the European Commission Vice President for Values and Transparency. His current portfolio is broad. It includes responsibilities over the rule of law, fundamental rights, infringement, citizenship, and civil and criminal justice. Between 2018 and 2019, Mr. de Elera also held a similar portfolio in the cabinet of EC Vice President Frans Timmermans, and he has served in various legal advisor roles to the Council Legal Service and the cabinet of the Secretary General of the Council. Thank you. Finally, but definitely not least, Associate Professor Veronika Bílková, many thanks for joining us. She's a member of the European Commission for Democracy Through Law, known usually as the Venice Commission of the Council of Europe. She represents the Czech Republic and has served on the Commission since 2010, including for a period as its Vice President. Notably, Veronika has contributed to the Venice Commission study on the emergency measures and the EU member states' responses to the COVID-19 crisis last year. Dr. Bílková is also a member of the managerial board of the EU Fundamental Rights Agency. She teaches at the Charles University in Prague, and she's also the Secretary General of the European Society of International Law. So thank you to all three panelists. Before we turn to your contributions, a couple of matters of order of business for our listeners that are joining us. We had over 120 registrations, particularly from the European Union, but of course around the globe. You will see that there is a chat button and a question and answers button. For the chat button, please feel free to drop comments should you wish. But for the questions to our panelists, please use the Q&A function that can be found at the bottom of your window. When you do propose questions, please note, is it for all the speakers or if it is for a particular speaker, and then we can try to accommodate as we go. There are some colleagues of mine who will be collating these questions and feeding them to me as I'm moderating. Two final things to say, that next week we're also launching a lovely bunch of webinars as an end to the Verfassungsblog Symposium. I will leave some space to Joelle at the end of our discussion to describe them. They are going to be quite momentous occasions for looking in depth at various aspects of COVID-19, rule of law, human rights, and other aspects. And there will be also an evaluation at the end of today's session, which we would really appreciate if you could complete and let us know how we have fared and how we can do better next time. That is all from me. With that, I would like to turn the floor to the virtual floor to Joelle. Joelle, please take us away with the findings of the report, key recommendations, and any other comments of consequence. Thank you.
I'm sure it's almost dangerous to say any other comments of consequence. But thank you so much, Paul, and good morning, good afternoon, and very warm welcome to everyone joining us this morning. As a very, very first brief point, I'm going to thank Paul for such an incredible, if not very deeply embarrassing introduction. It's been a great privilege to work with Democracy Reporting International on this report. I would say that it's a very, very important report because it offers us not only the opportunity to look back over the course of the last year and examine transversal issues affecting member states across the European Union, but fundamentally and importantly, offer recommendations on how we can all do better. So by way of very brief introduction, I realize that Paul has already introduced the report, but it's building first on a survey that we ran inviting 35 national experts across all 27 EU member states to contribute, to examine, to analyze the governmental responses, the state responses, the degree of judicial and parliamentary oversight that was afforded to measures that have been adopted in response to the COVID-19 pandemic. This report provides a comparative evaluation of EU member states' legal responses to the rising infection rates during the so-called second wave that arose between October 2020 and February 2021. This is all from a rule of law perspective, again, trying to measure the very best of governance, but also to identify some of the most concerning practices that we are seeing across the European Union. A few things to emphasize from the very beginning is first, the responses to pandemic across the EU have been primarily driven by national governments, specifically the executives, not necessarily the parliaments. Within the context of the EU, there's been a very limited role of coordination. Now, this goes back to the competences of the European Union, but what we see is that manifests as a great diversity of measures, diversity of strategies, diversity of approaches being adopted right across the European Union. Now, within the context of the survey itself, we gave all of our experts multiple choice questions, again, from this rule of law perspective, and asked them to evaluate on certain rule of law criteria, whether or not they had no concern, some concern, or significant concern. From this, we were able to identify transversal concerns, transversal critical concerns that are ongoing. Just to echo Paul in his, again, very lovely introduction, I'm really glad that I'm not blushing very obviously on camera right now. But these concerns manifested not only in a small minority of member states, but seem to appear almost transversely right across the European Union. Further research and further evidence supporting the conclusions and findings of this report came from the Power and the COVID-19 Pandemic Symposium, which I have the great delight of convening and organizing, which is coming to the end right now on the Verfassungsbog. It was also supported by Democracy Reporting International and the Reconnect project. But let's instead turn to these 5 critical areas of concern that were identified across EU member states. The first area of concern is that many COVID-19 measures introduced by governments using their executive powers do not necessarily have a clear basis in law. Now, all of these concerns I will be expanding on and giving some country examples, but in the Q&A, I'd also happy to give more and further information on this. The second area of critical concern that was identified across EU member states was that many COVID-19 rules are vague or change too quickly for people and implementing authorities, especially enforcement authorities, for example, the police, for them to keep track of or to adapt their behavior in response. I think I can imagine many people listening out now will appreciate times within the last year in which they were uncertain of the measures that applied to them and to their families. The third area of critical concern that was identified is the lack of oversight of executive action, the insufficiency of oversight, either from parliaments or from the courts. The fourth area of critical concern is that there has been little or no public consultation on COVID-19 measures. A final area, which is going to become increasingly important, especially as we come now to 14 and 15 months following the initial declaration of a global health emergency by the World Health Organization in January 2020, is that governments have not yet provided a clear exit strategy on how restrictive measures will be rolled back and eventually eliminated. Now, before I begin to focus in particular on these 5 areas of concern, there's one essential point I need to emphasize based on all my research over the course of the last year. Again, examining the responses in over 70 countries and supported by research far beyond my own, which is that compliance is more than creating rules. Public compliance is far more than governments creating laws. It's public trust, it's accountability, it's the capacity for us to understand measures. When laws are uncertain, when they are unaccountable, when they are unclear, when it is not possible to identify their legal basis for action, this undermines public trust and ultimately undermines public compliance with essential health measures. But in particular, let's focus just on the first area of critical concern. This goes to the lack of legal basis. This is absolutely not to say that all laws are not founded on a clear principle. It's absolutely saying that governments have been acting within the law in the great, possibly majority of measures, but nevertheless, we are seeing critical concerns arising right across the European Union. Within the report, we've identified different ways in which this is manifesting. For example, long and extended states of emergency and governance by decree could be unconstitutional. We saw this very concerningly with essentially governance by decree in Hungary through a series of amendments and introductions, essentially culminating in the possibility that the Prime Minister is the only one who can determine when an emergency can end, with very little parliamentary oversight and less scrutiny. We also saw this to a context in the Czech Republic, where the continuing declarations of states of emergency, particularly when Parliament wanted to bring back control within the legislature, was criticized. And at one point, one of the declarations was found to be unconstitutional. The second area in which we're also seeing this in the context of the legality of government action is when they are exercising powers granted by constitutions or ordinary legislation beyond their intended use. We've seen this in Austria and, for example, also in Slovenia. A third area that we're also seeing is where governments are relying on ordinary legislation which was not designed for that use, or it is outdated by modern democratic standards. And for example, we see this in Cyprus, where the government is currently depending on a pre-independence, a colonial law, which is not subject to the same expectations that we would have in modern democratic and rule of law governance. A third area is where, a fourth area is where there is a lack of appropriate legal basis or authority for government legal action. We saw this most critically in what was so-called the Mink Gate in Denmark, where the point that the Danish government declared that all mink had to be culled almost within a 24-hour period, the government were aware that there was no legal basis upon which they could make that order. Now, while measures were subsequently introduced to provide, for example, compensation to farmers in that instance, it is deeply concerning from a rule of law perspective that governments will proceed with orders that have real and tangible effects on individuals while knowing they have no legal basis for such action. A final area of concern within the context of legality, again examined in quite a number of EU member states, is whether certain restrictions of individual rights by governments may not be lawful, either within the constitutional framework or within the international human rights frameworks. For example, we see this in France and Poland. Moving to our second area of critical concern, many measures have been uncertain or unclear, or they change too quickly for people and for authorities to be able to adapt and to understand. Just to emphasize the point again, public compliance is related to the idea of public understanding. When rules change too quickly, when they're too vague, when they are not possibly grasped, then this creates problems for compliance. We've seen a very, very large number of states throughout the European Union identifying this, and a large number of bodies within these states have identified these concerns. For example, the Conseil d'État and the Commission consultative des droits de l'homme in Luxembourg has highlighted this an issue. Or, for example, in Ireland, where many people were unsure whether or not they were committing a criminal offence by leaving their house when the idea of what a reasonable excuse was not clear. We also see laws changing very, very quickly, too quickly for people to be able to understand and adapt. This is something we've seen in Slovenia and the Czech Republic. Even Germany, Cyprus, and Poland have identified too quickly changing laws. Sometimes laws have been introduced within hours of being created, within hours of even being announced. We've also seen situations in which governments have announced measures in the press without necessarily going first to parliaments or through official sources in which to communicate with the public. Beyond that, we also see issues in terms of minority communities and vulnerable communities, which in a reality of the pandemic are also the most affected by measures but also by the COVID-19 disease itself. For example, in Bulgaria, official sources were only communicating in the national language in Bulgarian, leaving minority communities of the Roma and the Turkish community unable to understand or access a lot of government information about the COVID-19 pandemic and measures being taken in response to it. This relates to the third critical area that we are finding, which is the lack or the insufficiency of oversight and review of government action. Parliamentary oversight and judicial review are not only foundational, fundamental elements of any democratic and rule of law society, the foundational of any member state of the European Union, but they also serve very practical and important positive benefit for response to the COVID-19 pandemic. This is in terms of the quality of law. Law which has been scrutinized, law which has been evaluated and debated is better quality. It correlates with higher public compliance, higher public understanding, higher accessibility of ordinary people. While all experts have raised some overall concerns, with only a minority not presenting such concerns, we still see a consistent lack of oversight in parliaments at a very fundamental level, almost a reticence to become involved. Less than half of the EU countries establish specialized parliamentary committees or publish reports or regularly schedule debates. And we see this as quite concerning, as only the Austrian, Czech, Estonian and German parliaments were identified as bringing significant levels of scrutiny to COVID-19 measures, particularly those that restrict human rights. This could be due to deference to government decisions during an emergency, and we see this certainly in Cyprus, but it's still all the more important, again, on that practical benefit of improving the quality of law and ensuring legal basis, that such parliamentary oversight is ensured and incorporated. Briefly, within the context of judicial review, and this is something that we observe almost in all emergencies, that there is an initial deference to government action, because again, one reality is government is always necessarily best placed to respond very quickly to an emergency, whereas parliaments are typically, due to important democratic processes, not as able to respond as quickly to emergency. But that initial deference to courts, or the initial deference by courts to government action, should change over time, particularly where we see increasing incursions to rights with questionable certainty and questionable legal basis. A final point, just in the context, I realize as it jumped onwards, a final context just to discuss in terms of oversight is the need also for independent bodies to be examining, to be engaging, to be considering. Independent bodies such as national human rights institutions in many states in the European Union have played a very important role, not only within the context of the pandemic, but prior to pandemic. They can take a very proactive stance. In fact, we've seen within the survey that independent bodies have been taking a more proactive stance in terms of engaging and giving oversight of government action than either the judiciary or legislatures. A fourth area of concern, again, that we are witnessing throughout the European Union is the lack of public consultation on COVID-19 measures. This is something that was identified as significantly concerning in a majority of EU member states. Public consultation is a key factor in quality regulation. It can bring new and innovative solutions, it can align government action with citizens' need, and it can help build ownership and buy-in to improve public compliance. Now, rather than focusing on the concern here, I will highlight some of the good practices we are seeing. For example, in Finland, very significant dimensions of the pandemic response have been determined by Parliament, but they've also had close scrutiny by the Constitutional Law Committee, which regularly engages in public consultation. And it invites external constitutional law experts to provide expertise. Similarly, in Croatia, we have a national E-Consultation web portal, which existed, I think, since 2015. And this allows citizens to directly comment on legal proposals, including on those limited to the pandemic. These are very important ways of getting people engaged. And again, having that degree of ownership, control, and improving the quality of legal measures. The final aspect that we did want to highlight is over the surveyed period and largely since, many, if not the greatest majority of governments have not provided clear exit strategies on how restrictive measures can be rolled back and eventually eliminated. Now, this is something beyond the question of whether or not states have declared a state of emergency. One point that I would emphasize is that some states have not declared a state of emergency simply because they were not legally enabled to. And for example, Ireland, where you were not able to declare a state of emergency in the context of a health pandemic. But instead, we focus on a different question, which is there needs to be forward-looking planning. It is so important in this context that governments stop merely responding and reacting to pandemic and look forward and beyond to exit strategies. This is something that we are beginning to see nascent proposals in some countries, but this is also an opportunity for the European Union in its coordination to step in and to encourage further coordination across EU member states. We again see initial proposals on this matter, and this is something that should be encouraged. As a final point, one of the core aims of this report is not only to identify critical concerns across the European Union, but also to present, to advocate important recommendations on what can be done better and what can be done now. In terms of these recommendations, we recommend strongly that in responding to the epidemic, governments should clearly identify the legal authority for their measures. Any reform of existing or the introduction of new health laws, including the preparation for future pandemics, should set explicit limits, conditions, and checks on government powers. In this context, I would actually highlight a lot of the work of the Venice Commission, who have presented excellent recommendations on the context of reform and in the context of the use of emergency powers and laws. Second, in the context of the uncertainty of legal measures, we would recommend strongly that policies and rules should be as clear as possible and made public in a timely and consistent manner. They should also include an evidence-based rationale. It's not enough to say we are bringing the numbers down. We must justify the measures that are having such great incursions on civil liberties and human rights. In terms of oversight of executive action, we recommend strongly that states should ensure effective oversight through dedicated parliamentary scrutiny, through continued public access to impartial courts, and engagement, government engagement with national human rights institutions. In terms of the lack of public consultation, to all the extent possible, states should be providing opportunities for structured feedback from the public, including also from the expert community and from civil society as part of the drafting and reviewing of COVID-19 measures. I need to emphasize a point which no doubt will be echoed so many times, which is we are a year later. We know so much more about the virus and the COVID-19 disease which it causes, that even where there's uncertainty as to the potential mutations in the virus itself, we still have the opportunity to be allowing, encouraging, and advocating for this engagement. As a final point in the context of exit strategies, and as a matter of priority, governments should develop and disseminate a staged and sequenced exit plan for the reduction of COVID-19 measures, which should be updated as new information becomes available, including the possibility that measures will need to be reintroduced if the prevalence of the virus risks exponential growth. The great worry and reality and concern of a changing pandemic is we do need to respond, but we need to respond with evidence, with rationale, with certainty, and also with legality. As I know from not only my research, but from observation, history teaches us that our core constitutional values, the foundational values of the European Union, democracy, the rule of law, civil liberties, they are more important in emergency. They are more important in crisis. That these values are meaningful not when they are convenient, but when they are inconvenient. Knowing I have taken a lot of your time this morning, I thank you for listening and will now pass on to the next fantastic speaker. Thank you.
Many thanks, Joelle, for this detailed exposition of the 5 key transversal problems that we're seeing across the EU and the core recommendations to public officials and bodies across the European Union. Thank you for that. I will now pass over to Álvaro to give his perspectives on the member state responses from the European Commission view. Of course, the European Commission is currently engaged in the rule of law report consultation process, so there may be some observations from that regard as well. Maybe one thing for anybody that does have questions, just a reminder, please plonk them in the question and answers box. We unfortunately are not taking verbal comments or raised hands in this discussion, but do drop your comments and questions, comments in the chat box, questions in the Q&A box, and we will be sure to address them. Many thanks, and Álvaro, over to you.
Thank you, Paul, and good morning. Allow me to start by saying that it's a pleasure to be here in such a distinguished company and also to have the possibility to present, of course, the views of the Commission in this very important matter. Indeed, it is an important matter. I think we have seen this report is very timely and it's extremely useful also for the Commission's work, but we have seen also a number of other reactions from the academic community and from national institutions, not being the executives. But also I have to say, this is well known as well, also from the Commission side. As you very well know, last year we issued the first rule of law report, covering the situation of the rule of law in the 27 member states and in the Union as a whole. This was the first ever. Before that, we had no such comprehensive analysis of the situation of the rule of law in the Union and the member states. And in the process leading to this first exercise, we identified 4 areas that would be the subject of the study, which were the justice systems, anti-corruption, the situation of media, and then general checks and balances. However, because of the COVID situation at the very last minute, maybe not so very last minute, but it was certainly not planned, we introduced a further subject of analysis, which was indeed the measures, emergency measures and others taken by member states in the context of COVID. And this is featured prominently in the first rule of law report of last year. It will also feature prominently in the next rule of law report, which will be issued in the second half of July this year. And we expect, hopefully, that it will be the last time that we will have to be dealing with this matter. But just to know that this shows how the Commission has identified as well that this situation created by COVID was a situation that served very much as a stress test to the rule of law checks and balances in the different member states. So what did the Commission then identify as main, if you want, lessons learned? And this, before I go to the consequences in the 4 different headings. Well, first, indeed, that there was a need to ensure a loyal cooperation between state institutions. And this because one thing that was noticed was that there was a certain strain in the relations between state institutions, because indeed in emergency situations, what tends to happen is that the executive accumulates power, and this is done at the expense of other state institutions, or in general at the expense of the checks and balances in a state. Then there was a clear impact as well on media and the civil society at large. I will come back to this in detail, but this is certainly a lesson learned, and we will pay special attention in this year rule of law report to the situation of media and the role of civil society in general. And then a third one that is evident that we are seeing the effects now as well is the resilience of justice systems, because again, this is also a stress test for justice systems. They were faced with situations such as the interruption of their activity because of the lack of possibility of having physical meetings and sessions and so on, increased backlogs. So this is something that of course we will have to look at in the future as well. Important to know, now it was COVID, it was a pandemic, but of course many other emergencies can occur. This is very well known. I think what of course distinguishes this emergency from others is that normally other type of emergencies are geographically limited, and this has been a global one, and therefore the effects can be seen all around the globe, and certainly in the 27 member states of the Union. So that made it also easier to a certain extent to see the comparative impact in the different member states of the crisis. Now, when we looked at the impact in the 4 different headings I was mentioning, first on justice system, I mentioned this already. This was a huge stress test. Some member states have done better than others. Something that the crisis has clearly shown is that digitalization is more important than ever, not for the sake of it, but to ensure that justice systems are first more resilient, but also, and this is important, that they become more transparent and more accessible to the citizens. Because as I was saying, digitalization is not just a question of changing working methods and making justice systems more efficient. It is also about that, and this is important. But what we would like to achieve as well by digitalization is an increased transparency and a more accessible justice systems to citizens at large. In this context, of course, the recovery plan of the European Union is going to provide quite an important number of funds to member states to increase digital national administration, and it is the intention of the Commission that a huge part of these funds go also to the digitalization of justice systems, and not just of tax authorities or others, as is normally the case. Now, when it comes to anti-corruption, checks and balances have also suffered in general. But there has been also another factor which is important, which is the possibilities for corruption to appear have increased as well, very much so, because there were urgent procurement procedures for medical countermeasures for medicines and so on. This gave rise in a number of member states, this is public knowledge, to corruption problems, which of course in turn, because the checks and balances systems were under stress, were not so easy to control. On top, we will have, I just mentioned this, immense amounts of money now coming from European funds to the member states. And this again will increase the possibilities for corruption at the national level. The good thing is that now we will have the budget conditionality regulation to look at this. We will also have the work of the European Prosecutor's Office, which is starting on the 1st of June this year. And we expect that with these reinforced tools, we will be able to control this phenomenon better. But it is true that the possibilities for corruption and the checks and balances to control them have made it more difficult for this specific chapter of the rule of law to be respected. Impact on media, mainly, I would say, in 2 different fields. First, the situation of a number of media outlets, the economic situation is very dire. They have been deprived of income. That means the work has become more difficult. And this immediately has an impact also on accountability, because of course, when media cannot do their work, then the accountability of public authorities diminishes immediately. Then the second and probably more worrying dimension of it is that very often when media have tried to do the work, they have been depicted as enemies of the state or enemies of the health situation in the member states. And this is a very worrying concern that we have seen in many places. They have been subject to threats, physical intimidation, even aggression. And all this in the context, as I was saying, of their work being presented as making it more difficult for the executive in the different member states to tackle with the situation created by COVID. In this respect, I can also say that we have a number of initiatives that will be coming from the Commission between this year and next year to protect the physical integrity of journalists, to address also the difficult economic situation of media outlets to the extent this is possible, and also to protect media pluralism as a whole, because the media pluralism landscape in the member states has suffered also due to the economic situation mainly created by COVID. Now, when it comes to the fourth heading, which is checks and balances, again, I've mentioned this, it was a huge stress test. On the one hand, the checks and balances institutions in different member states, constitutional courts, ombudspersons, and so on, they have had an increased role because of COVID. But that, of course, means that that's because the underlying situation was that there was a need for an increased role for these checks and balances. And often it was difficult for them to cope with this increased activity on the one hand. On the other hand, again, we have seen a decrease in the loyal cooperation between state institutions because reactions from the executive branch have not always been, let's say, as respectful as they should have been to the activity of the other powers of the state. And that is something that we are very worried about. Now, for 2022, in the report, as I was saying, you will see specific attention to this, probably even more than for last year. We are going to focus on the, as we did to a certain extent already, on the use of emergency ordinances and legislation procedures, on the checks and balances, and specific attention on the situation of media. Coming now to the report of Democracy Reporting International. Thanks again. It's a very useful piece. It's absolutely necessary. As I was saying before, we see this as a huge stress test. And I think what is important is not just that we do things right now, but also that we learn the right lessons. And there's plenty of lessons to be learned. There will be more emergencies to come in the future. And what matters is that we get things right so that in the future we can cope better with this kind of situations that no doubt will continue to occur. Going to the different headings of the report, there's the lack of clear basis in law and the fact that legislation is changing often and it's vague, lack of public consultation and lack of exit strategies. All this is true. And we consider that this is indeed a problem. However, for us, the crux of the matter is in the third point, the overview, because rule of law is about doing things right, but especially about making sure that if things are not done in the right way, we have ways to correct this. For the Commission, this is really the crux of the matter. And therefore, our main concern here is to ensure that overview of measures that are maybe not perfect because they were adopted in a rush, or maybe there were other intentions behind. I will refrain from assessing this, but whatever the underlying intention, what is clear is that what matters for us is that there's a correct and thorough overview. First and foremost judicial, but not only. There has to be a first and foremost judicial overview, but also other institutions of the state, the parliament, of course. Parliament, however, and executive power very often are in the same hands. So this is not necessarily doesn't have necessarily a great added value, but judicial overview, but also overview by civil society at large, by media, by academia, by ombudspersons. This is essential to us, and this is where our focus is going to be in the next years, if you want, to make sure that this overview of emergency measures can take place in the right way. I have to say, of course, that the problem to a certain extent with this overview is that often it takes time. We have, of course, also emergency procedures before constitutional courts or Supreme Courts to strike down sometimes legislation that is adopted in the wrong way. But some other times, judicial proceedings to check the legality of certain action by the executive or even by the parliament is something that takes time. So we will only be able to assess the final impact on this after a certain time passes. This, I think, is a structural difficulty that is very difficult to deal with, because as part of the rule of law, of course, is the respect of the applicable procedures. And that means sometimes that things take time. This has not been the case for many governments, because they have made extensive use of emergency procedures. And this is something that is subject to criticism, and very rightly so. When it comes to the control of this action by the executive, we should follow the normal procedures. That means it's going to take some time. Well, okay, that's something we have to factor in, and there's nothing to be done about it. More generally, I think I would agree indeed that the one lesson to be learned here is that indeed public trust is essential in this case. And public trust suffers very much when there's a public perception that the measures adopted are arbitrary because they are changing often, and they are being adopted without sufficient basis on scientific advice or technical advice. And also when the efficacy of these measures taken by governments is not clear. So if it is not clear that the measures taken have a real positive impact, be it in the economy or in the public health or whatever it is, then immediately they are questioned by the citizens. So, and the two are linked, because of course, if we are changing the approach every 2 or 3 weeks, then people start legitimately asking themselves, well, that means probably we didn't get it right 3 weeks ago, and maybe who knows if in another 3 weeks we will have a different approach. So this is indeed a problem that we see, but I must say for the Commission, this is a problem, if you want, of policy making, and not so much necessarily related to the rule of law as such. This is probably a problem of poor policy making, again, that is not based on solid foundations, and therefore it is subject to legitimate criticism. A second general consideration on this, and with this I think I will be closing my intervention. I come back to what I was saying before. First point I just mentioned, public compliance and trust suffers if measures are considered not effective and are arbitrary. But the second point that is important for us is the manipulation of a public debate. The manipulation of a public debate has also been a very worrying development in these times. Part of it has been disinformation, deliberate action by malicious actors in the public debate, trying to influence public opinion with false or misleading information, but also, and this is something I referred to already, also interventions mainly by executive powers, trying to denigrate the action of other powers of the state or of civil society, also of European institutions. This is something of great concern to us, because we consider the damage done by these kind of actions is something that will stay for long and will not be so easily corrected. Because when the public starts considering that certain state authorities are not acting in the public interest, or that Brussels is not acting in the public interest, and that only the executive branch of government is in the possession of the absolute truth, then democracy as a whole suffers. And this is something we look at with great concern, and we will also try to see how to tackle this in the future. And if you allow me, I will leave it then. Thank you very much.
Thank you very much, Álvaro, for these very pertinent remarks, covering both the rule of law report and what you're seeing there, as well as the immediate reactions to our own findings. And I must say, as somebody that comes from the anti-corruption arena history, that's nice to hear also the link made to the corruption. And as an organization, TRI is an organization that works on issues of disinformation and tracking disinformation online. It's very pertinent, the link that you have made to this erosion of trust by nefarious actors or manipulation of public opinion. So thank you for this contribution. Now turning to last but definitely not least, Veronika, please take it away. And folks, if you would like to have some questions, do drop them in the Q&A box. Thank you.
Thank you. Good morning, good afternoon to everyone. And many thanks to Democracy Reporting International for the kind invitation to join this very interesting and timely event. I would like to congratulate the author of this interesting report. So I read it with great interest, but I must say I also read it with great sadness, because the concerns that the Venice Commission raised in its report last year seems to be largely validated. So from that perspective, my presentation will be kind of a pre-echo of what has been said by Joelle, because what we formulated as concerns has reappeared in your report as the description of facts. So what I intend to do is to introduce the Venice Commission position on these issues, obviously speaking in my private capacity. And I intend to proceed in 2 steps. In the first step, I would like to briefly introduce the Venice Commission, because I am not sure that everyone is familiar with this body. And I would like to provide you with a short overview of the reports that the Venice Commission has adopted and that are of relevance for this debate today. And then in the second part, I would like to draw your attention to certain concerns and standards that the Venice Commission has identified in its reports. Obviously, the reports are very comprehensive. They are over 55 pages altogether, so my presentation will be a large simplification, and I am very happy to elaborate on any of the elements that I will mention, as well as on anything I will not mention in the debate. I have prepared a short presentation, so I will try to share it with you. So please let me know whether you can see it. Yes, great. So let's start with the first issue, a couple of words, a short introduction to the Venice Commission. So the Venice Commission, by its right title, the European Commission for Democracy Through Law, is an advisory body of the Council of Europe, which specializes in the area of constitutional and international law. It is an interstate body, but it is composed of experts, especially academics like myself, or judges from the Supreme Courts and constitutional courts. And as you can see in the map, the membership of the Venice Commission is much broader than that of the European Union and even that of the Council of Europe. At the moment, the Venice Commission has 62 members. That means 47 members of the Council of Europe, plus Kosovo, plus 14 non-European countries, including the United States, Canada, Brazil, Mexico, or the Republic of Korea. It also means that when the Commission issues certain opinions or certain studies, then generally it takes into account not only the situation in Europe. The Venice Commission adopts 2 main types of outputs: opinions and studies. The opinions are normally country-specific, and they assess a concrete piece of legislation adopted or submitted for adoption in a certain country. Studies, on the contrary, are general. They deal with a general topic. For the moment, to my knowledge, there has not been any request by states or by international organizations to issue an opinion that would relate to any specific piece of legislation adopted directly in the COVID-19 crisis. So I can't introduce any specific opinions on the topics that we are discussing today, because for the moment, no state and no international organization has requested, to my knowledge, such an opinion. So we are left with the general studies. And here, fortunately, the Venice Commission has been very active, not only last year. So let me move to the general studies that are relevant for our debate today. First of all, I would like to introduce 2 studies which predate the COVID-19 crisis. So they were adopted prior to the outbreak of the pandemic. The first one is the Rule of Law report, which was adopted in 2011. This report defines the concept of the rule of law and identifies the 6 main elements of this concept. That means legality, legal certainty, the prohibition of arbitrariness, non-discrimination, access to courts, and some human rights related to the previous concepts. 5 years later, in 2016, the Venice Commission adopted the Rule of Law checklist. This checklist contains concrete benchmarks, usually in the form of questions, which make it possible to assess the state of the rule of law in a specific country. And I need to make 2 remarks with respect to this checklist. First of all, the Venice Commission is not a body that would use itself, this checklist, to undertake a general assessment of the member states. So there is no universal periodic review of the rule of law within the Venice Commission. It would be beyond the mandate of the Venice Commission to make such an assessment. So the checklist is there for states or for international organizations, such as the European Union, for experts, for NGOs to use. And the second remark, and I think that's quite obvious, but I still like recalling it, the report and the checklist both stress that the rule of law concept is not an all or nothing concept or all or nothing issue. It rather comes in scales. And there is no perfect rule of law abiding state. So states should be assessed on a scale, and obviously they can move on this scale over time. So the state of the rule of law can increase or decrease in a specific country. The battle is never over. It's always, even states which perform very well in this respect at a certain point of time can show signs of rule of law backsliding later on. And we've seen concrete examples of this move in Europe, both prior to the pandemic and during the pandemic. So these are 2 general reports, and later on in 2020, the Venice Commission adopted 2 reports which are directly related to the COVID-19 crisis. The first of them was issued in May 2020, and it's called Respect for Democracy, Human Rights and Rule of Law During State of Emergency. So it's from May. The second one was drafted over summer and then formally adopted in October 2020 at the request of the European Parliament. So this one is specifically focused on the EU member states, while the first one is more general. The second one is the report on the measures taken in the EU member states as a result of the COVID-19 crisis and their impact on democracy, the rule of law, and fundamental rights. And I will, before I turn to the second part of the presentation, when I will focus on the content of these 2 reports, I need to stress that, as you can see from the dates, it's May and summer 2020. So these reports were adopted after the first wave of the pandemic. They do not take into account what has happened since then, quite obviously, and they were based on the limited data and limited practice which was available at that time. And you need to read them in this slide. So what they did was not so much assessing what had already happened by then, because not so much had happened by then, but rather restating some basic principles and issuing some warnings, or rather drawing attention to some areas of concerns. So let me move to these basic principles and areas of concern. So the basic principles are general conditions. And just very briefly, I know I will simplify a lot, but there is no other way to proceed. So the basic assumption that the Venice Commission indicates in the reports is that the state of emergency may obviously entail limitations of and derogations from human rights, as well as shifts in the distribution of powers. In itself, this is possible, this is lawful. And as has been already mentioned, this shift normally means strengthening of the powers of the executive in itself. This is not an unlawful act. Yet there are some conditions which obviously apply to any measures that are adopted in such times. So for the short-term measures, the 3 main principles that are well known and that are stressed again and again are the principles of necessity, proportionality, and temporariness. So any measure, and that means both limitations of human rights and shifts in the distribution of powers, need to be somehow linked to the state of emergency. So they need to be necessary to overcome this state. There needs to be proportion between these measures and the situation on the ground. And all the measures may stay in force only for the period absolutely necessary to overcome the situation, to overcome the emergency which has arisen. So that's so much for the short-term measures. States might be inclined to also adopt certain long-term measures in the state of emergency. The Venice Commission stresses that long-term measures should be exceptional because we know this well-known saying that hard cases make bad law. And I would say that hard times make bad law as well. So states should think twice before they decide to make long-term changes in exceptional situations. If they decide to do so and to adopt some long-term measures, then the two principles that are mentioned in the presentation apply. The principle of acquired rights and the principle of checks and balances. That means that if the states decide to somehow interfere with the protection of human rights, they need to make sure that the overall level of this protection does not decrease. And the same applies to checks and balances. If, for instance, one organ is given additional competencies for over a long-term period, then that needs to be balanced by either additional competencies given to another body or by a strengthened oversight, so that we keep this and we don't get to this. So these are the general conditions. And now the last slide, some specific concerns that the Venice Commission voiced in its two reports. And you will see that it's almost incredible how they correspond to what has been described in the report, what has been identified, what has really happened. So the main concerns or the main risks, threefold, and they have already been introduced, so I can be rather brief here. The first one is the absence of a clear legal basis. The Venice Commission stresses again and again that any measure taken needs to have a very clear basis. It needs to be known whom is entitled to do what, in which circumstances, and for how long. And moreover, the Venice Commission stresses that it's really important to have the basic rules applicable in times of emergency enshrined at the constitutional level. So there needs to be some basis at the constitutional level to know how the state will be allowed to proceed in the times of emergency. So that's the first element. The second one, and again, you will immediately link it to the previous presentations. The Venice Commission warns against vague and imprecise and unjustified rules for the reasons which have already been mentioned. So such rules, first of all, are in clear violations of the rule of law principles, of the principles of legality and legal certainty. Moreover, they make it very difficult for citizens to know what they should do in their everyday life. Moreover, they also make it very difficult for courts to assess, and for other supervisory bodies to assess to what extent the measures comply with the principles I mentioned earlier, whether they are proportionate, necessary, and whether they apply for the appropriate period. If we don't know why they were adopted in the first place exactly, there is no way to assess them. The Venice Commission also warns against rules that would be discriminatory and arbitrary. And we have definitely also seen some signs of that, for instance, age discrimination in some areas, or a very random based rules that seems to be arbitrary, that again has been described in the report. And the last issue, again, nothing new, that has already been mentioned several times. The Venice Commission stresses the importance and warns against the risk of the absence of scrutiny and oversight. We distinguish two types of scrutiny or oversight, the external one and the internal one. The external one means by actors outside the state, such as the European Union, and the internal oversight is built on four main pillars. The first one, obviously, is the legislative oversight by the parliaments. The second one is the judicial oversight by courts. Then we have the human rights oversight by national human rights institutions or ombudsman institutions. And finally, we have the public oversight by media and by the public. And all these four pillars need to be really in place and need to be fully operational to make sure that the state does not engage in the rule of law and human rights backsliding. So that was the two Venice Commission, or the four Venice Commission reports in a nutshell. And then just very last word on the report, on the element that I have also found very important, and that was already mentioned by Álvaro, and that's the element of the public trust. That's something that the Venice Commission has stressed since its first reports on the rule of law. We have always stressed the importance of the environment in which the concept is implemented. So I would like to finish by quoting one sentence from the rule of law checklist, which relates to this. So I quote now: "The rule of law can only flourish in a country whose inhabitants feel collectively responsible for the implementation of the concept, making it an integral part of their own legal, political, and social culture." If this is not done, and I'm afraid that probably the undermining of the public trust will be the worst consequence of the pandemic itself and on the measures adopted during it, then we will really have a large-scale problem in probably a big number of countries in Europe. My apologies for ending my presentation with these rather pessimistic words, but hopefully the debate will go in a more optimistic direction. Thank you for your attention.
Thank you very much, Veronika. With that, we have completed the three preset contributions from our speakers. Many thanks for all the insightful contributions. Now we will turn to a Q&A. There are some questions that have been contributed in the question and answer box. There are also some that have been thought about in advance as well that might be useful to discuss. So basically, I will turn one by one to some of you, and if there is anybody that wants to add on at the end, just feel free to jump in at the end. Joelle, maybe starting with yourself, there's a question from Jose Antonio Morena saying political action does not only fall on governments. What happens when opposition parties decide to use pandemic as a political tool of opposition and there is no climate of consensus against pandemic and only confrontation? What happens then? That's the first question I will put to you. And the second one is, given your work also on the first symposium, how would you compare the member state responses to the COVID crisis between then and now? Thank you.
Two excellent questions. So thank you so much to both questioners. First, in the context of political opposition, this is certainly something that we're seeing, that particularly in the first phase of the pandemic, when a number of countries, not only here in the EU, well, technically I'm in the UK, but what was the EU? Not only in the European Union, but also globally, a number of countries were going through elections. So what we saw at the first phase was minority governments, it was interim governments, and it was also a very, very divisive lack of government. Within the EU, we saw this in Ireland and we saw this in Belgium. One of the great challenges in the context of parliamentary democracy is to distinguish oppositionism purely for the sake of political point scoring from truly engaged democratic debate and oversight. Now, it is an absolute realized truth. It's evidenced that when opposition parties engage, when they scrutinize, when they give critical scrutiny to improve the quality of law, the quality of pandemic measures, things are better. There are higher levels of public compliance, there's higher quality law. What is problematic is political point scoring, where it is not engaging in democratic debate, it's merely trying to undermine for political reasons. The problem is that this actually creates additional pressures, stresses on the other checks and balances of a legal system. It would almost require the underlying law and legal basis to be very clear in its limitations, to be strong in its application, but it also could require pressures on the other institutions of the country. For example, in the courts, in institutions and civil rights organizations, in independent institutions, to be taking up the mantle of scrutiny and oversight within that democratic debate and within that democratic forum. So I do fully recognize that it's an issue. It's certainly an issue in terms of quality of law that we're seeing. It's not something that I necessarily have an easy solution to right now. In the context of the second question, which, if I remember, was comparing EU member states from the very beginning of the pandemic to now. So just as a brief context, I've run 2 symposia now, looking at about 60, 70 countries, including all EU member states, and the first 3 months of the pandemic, and now a year later. What stood out to me, and in this context, I'm particularly going to be echoing Veronika, and actually to an extent to Álvaro, which is we're not seeing an improvement. In fact, in many cases, we're actually seeing a continuation of the same concerns that we saw at the very beginning. Constantly, governments seem to be reacting to the latest information rather than seeing looking forward and seeing how best they can be responding to it. We're seeing the same issues. One thing that I'd also need to emphasize is we're also seeing issues emerging from countries that initially were identified as being quite either innovative or capable. For example, Sweden, and we have a fantastic Swedish report, which I highly recommend you reading on the symposia. But Sweden has identified some concerns in terms of parliamentary oversight, in terms of the degree of oversight of government action and the competences of government, or the lack of exercise of competences. So the reality that we're seeing a year later is either not much has changed, and this is concerning in its own way, or there are emerging issues which arise as a consequence of over-reliance on emergency powers. Again, it relates back to these 5 same concerns: no public consultation, very little oversight, very little certainty, and also, to a degree, a lack of legal basis still being not used. My 2 answers.
Thank you very much, Joelle. With this, maybe turning to Álvaro, there's a couple of questions that might be of particular relevance to you. One is, was asking, I think that many states went to having online trials very quickly. Did you find any problems with over-reliance on online trials or other IT tools to conduct trials? So that's a very practical question. And another one to follow up, of course, the European Prosecutor's Office is a highly welcome development in the EU. However, some EU member states, particularly some with which there are particular concerns, have opted out. So how will the Commission tackle the danger of corruption in these countries? Thank you.
Yeah, thank you very much for the 2 questions, which are indeed very pertinent. First, on the use of online trials, short answer, no, we have not detected any problem with that. Actually, what we would like to see, and we are measuring this not just in the context of the rule of law report, but also in the context of the Justice Scoreboard, which will also be very soon released for this year exercise, is that member states should have at least the possibility to fully conduct trials online by means of IT platforms. And that means many things. That means the possibility of giving testimony from afar, to do the hearings online, also to provide online interpretation when this is needed, to have access to the rulings and the judgments of the courts and all the pieces of the procedure. So this is something that the Commission considers a desirable objective, and we are working in that direction. So for the time being, we have not detected any problem linked to this, and we would actually say that from our view, there's not even a possibility of an over-reliance, because we would like to see this happening from beginning to end of the judicial proceedings. Of course, this should not be an obligation. This should be only a possibility, but that's a different matter. On the second, the European Prosecutor's Office. Allow me to reformulate. It's not that certain member states did opt out. They decided not to opt in, which is a different matter, because this is a reinforced cooperation. Okay, so this it's not that they decided I'm pulling out. No, they decided not to join. Having said this, is this something that we consider a good situation? No, we would prefer to be everybody in. Right now we have 22 member states in. That means Denmark is out because of the protocol issue. Basically, they do not participate in these policies. Then we have Sweden and Ireland that decided not to participate for other reasons. And then we have 2 other member states, Poland and Hungary, that probably have their own reasons not to participate. We are working at least with Sweden and Ireland to try to convince them to join. Now, on the 1st of June, as I was saying, the prosecutor's office will start working. It will take some time until it's fully operational, but we expect this to happen very, very soon, in any case, within this year. Now, answering the concrete question, well, it's not that anti-corruption mechanisms and controls have been invented with the EPPO. They already exist in the European Union. As you know, we have OLAF, and we have also audit systems in the Commission and also in the member states, and we have the Court of Auditors. So there's already quite a number of systems and mechanisms to make sure that member states do what they're supposed to do. On top of this, we have now, I mentioned this before, the budget conditionality regulation. So member states should be very careful. I know they're careful, but they should be extra careful, because if they're not, what can happen then is that in the future, if checks and balances and control mechanisms do not do their work, they will see that the funds are cut off, while at the same time, member states will remain obliged to provide the funds to the final beneficiaries. And this is also important. So it's not that NGOs or universities or other institutions will be deprived of funds. No, member states will not receive the funds from Brussels, but they will have to pay to the final beneficiaries. So they have to be very careful. And I'm sure they will be extra careful to make sure that these measures are not applied to them. Thank you.
Many thanks for that, Álvaro. Veronika, turning to you, a couple of questions. One question from Amal Karaki. I hope I pronounced that right. The need for legal basis for the measures implies that there are gaps in the Constitution or any other legal framework, or is it a matter of oversight during implementation? That's question one. And question two, of course, a reoccurring narrative holds that all the EU member states in principle respect the rule of law and human rights better than the ones that joined the EU in 2004 on. Does this hold with the way the COVID-19 pandemic is tackled, do you think, in terms of the research that you have seen? And maybe, Joelle, you could weigh in on this at the end as well. Thank you.
Thank you for the 2 very interesting questions. If you allow me, I will start from the second one, and I will answer in my private capacity, because as I mentioned earlier, there is no overall assessment of the situation in all the EU member states by the Venice Commission, going beyond the reports that I introduced already. But I think the answer to your question is actually contained in the report that Joelle prepared, because if we look at the scheme, then at the different charts, we see clearly that that there is no dividing line, and there is definitely not a dividing line between so-called old and so-called new member states. I would rather say that there are 2 main factors that account for the way and the degree to which states manage to deal with the COVID-19 pandemic in compliance with the rule of law. So the first factor is the legal framework. I think from that perspective, the COVID-19 crisis has really exposed the imperfections which exist in different legal frameworks across Europe. That's the best test we have ever had. And it depends on, it's largely for states to decide how they react. And here, this is interesting to see the differences, because we see that some states try to fix the deficiencies that have been exposed by the pandemic, while others try to benefit to use these deficiencies for their own purposes. And the dividing line is definitely not easy to be drawn. And it's definitely, I repeat once again, not one between old and new members. So that's the first factor. The second factor is what I would describe as a general climate in the society, which encompasses again this element of public trust that we discussed earlier. Here again, I would say that the COVID-19 pandemic has exposed the divisions that exist in all the societies and has exacerbated these divisions. And the two issues are partly related, because if the public sees that there is no reaction to the obvious deficiencies in the legal framework, or that even those in power explicitly use these deficiencies for their own purposes, then that undermines the public trust. On the one hand, the public trust in the government, but also on the other hand, the public trust in the rules themselves and in the concepts of the rule of law, democracy, etc. So that's why I mentioned that I see this as a very dangerous development, something that we really need to think about very carefully and to try to stop this development as soon as possible. Now, going back to the first question, I will just open the chat to see it. So the legal framework needs to be in place, if I understand the question correctly. So the legal framework, the legal basis needs to be in place at the moment the measures are adopted. And the oversight is there just to check whether those who adopted the measures acted according to the competencies entrusted to them. The legal framework is a must. There is no discussion about that. I mentioned, but this is already a recommendation, that in the Venice Commission perspective, it's really important to have the basic rules enshrined at the constitutional level. However, the Venice Commission also has repeated several times that let's put it this way, when the legislation is in place and it's not at the constitutional level, then this is not a violation of the rule of law, though it's not the optimal situation. So the level is not so important. The existence of the legal basis is necessary, and oversight is there to check whether this legal basis is in place. And now just one word on the oversight, because another problem that we have seen in a couple of states is the diversity of approaches within the oversight. We have had a couple of states in which the same measure has been assessed differently by different bodies, for instance, by different courts at the same level. And this is, again, a very dangerous phenomenon that needs to be discussed and dealt with, because if the oversight itself is unsure about the legality of the measures, then that sends a very confusing message to the public.
Thank you, Veronika. Joelle, I wonder if there's anything that you would like to mention in the difference between older member states and the newer member states, in inverted commas. And then we have two final questions to the panelists to make sure that we close out on time. Thank you.
I'm largely going to be echoing exactly what Veronika just said, and also underline within the context of our report. We were neutral as between East-West, Old-New, North-South, Northeast, Southwest. We're absolutely neutral because these are issues that we're seeing transversally. These are not issues that arise just in one part of Europe only. However, and again, to echo and underscore exactly what Veronika has just been saying, we are seeing a trend towards executive dominance, if not hypertrophied executive power. One of the most concerning developments in the context of the pandemic and the ongoing pandemic, the sheer time that we are now living in pandemic, is that we're witnessing emergency creep. We're seeing states that had previously been tending towards rule of law backsliding and democratic deconsolidation, taking this as an opportunity to entrench executive powers and to remove parliamentary and judicial oversight. This is a tragic reality in many member states in the European Union. But I would again emphasize that the critical issues that we've raised today are not East-West, North-South, Old-New.
Many thanks for that, both Veronika and Joelle. And then we're turning to two last questions, one which is perhaps more straightforward and one which is a complicated one. So the more straightforward one is from Tomasz Falszeta. There's a question, is there any specific guidance on how to assess the necessity and proportionality of measures justified on public health grounds? If there's any resources that people are aware to mention here. I believe Advocates for International Development have done some work on this. And the second, which is a little bit more complicated and it's very pertinent, is the question from Ioana Cornescu. How democratic and respectful to individual rights and liberties is it to divide citizens into vaccinated and non-vaccinated with legal consequences that the second category may have less liberties? This is a big topic, so maybe surface comments would be appreciated. Many thanks. Perhaps Álvaro, I'll turn to you to start with, and then we'll finish off with Joelle and Veronika. Thank you.
Thank you, Paul, and thank you also for the questions. Now, very briefly on the first one, I think I'm not aware of anything specific, but of course the viewpoint of the Commission is that this principles apply no matter what the underlying cause for adopting certain legislation. So I don't think there should be anything specific or differentiated when emergency measures are adopted on public health grounds. On the second. Yeah, indeed, it's a big topic. Now, the thing to say is, for instance, that we have a proposal for what is called a digital green certificate, which would allow people to exercise their right to free movement within the Union with less limitations. Does this create a discrimination with people who have not vaccinated? Well, this is certainly not the idea of the Commission. And for instance, in our proposal, it is clearly spelled out that vaccination is not a precondition for exercising free travel. So that's the first thing. The second thing is alternatives are being offered so that the certificates will not reflect only the fact that a person has been vaccinated, but also alternatively that she or he had a PCR test or went through COVID. And this is to make sure that people who could not have a vaccine or decided not to have a vaccine have alternative means of showing that they are good for traveling. Having said this, the objective situation of a person that is vaccinated and that which is not vaccinated is not the same. That we have to accept as well. Of course, the exercise of fundamental rights should not be made dependent on vaccination or not vaccination. But I have to stress that discrimination can only take place if we are treating differently persons who are in the objective same situation. And being vaccinated and not being vaccinated is not the objective same situation. So that is something we have to keep in mind. I'm not justifying by this the limitation of fundamental rights for people who have not vaccinated. We are against this and we will control this very much. But I'm reminded that the situation is not the same. Thank you.
Thank you very much. Then turning to Veronika.
It's a surprise because I was supposed to be the last one.
Oh, my apologies.
No problem. So with respect to the first question, the principle of proportionality and necessity, there is obviously quite a rich case law on these principles in all international human rights bodies, including the European Court of Human Rights. At the national level as well, there are a lot of soft law instruments, including some of those issued by the Venice Commission, which go into details of the application of these two principles. And obviously, since we are already 15 months or how many into the pandemics, we already have the first case law related specifically to the COVID-19 pandemic so far from the national level. And obviously, we find that the two principles applied in this case law as well. So we have some grounds on which we can rely in this respect. So that's for the first question. The second one, here I think I've largely subscribed to what has been said by Álvaro. So we obviously need to make sure that the principle of non-discrimination is respected here. But the principle of non-discrimination is based on the idea that people who are in a comparable, reasonably comparable situation are not treated differently unless there are some reasonable objective grounds. So it's very difficult to apply this test in abstracto. We would need to assess every concrete situation separately, and then we would need to see whether this test is met or not. That means whether the two persons or whether persons are in a comparable situation and whether there are or are not objective and reasonable grounds to adopt different treatment with respect to them.
Many thanks. And with that, I'm going to turn over to Joelle to respond to these questions and also to mention the webinars that are happening next week, which we highly encourage you to tune into. There's going to be some excellent discussion. And maybe at the same time, you will see a link coming in your chat box in a moment to the evaluation of the event. So we would really welcome your brief comments. It will take only a minute to do. And of course, it will help us to improve and make sure we do right and better next time as well. Joelle, over to you, and then a final close from me. Thank you.
I shall endeavor to be brief to two very, very good questions. Again, as something I think I've said a little bit too often, I'm going to echo my two co-panelists. There's a wealth of information available being published not only by the European Commission, but also by the Council of Europe, and the Venice Commission have been really fantastic on advice and guidance on these issues. Second, just in terms of vaccination and vaccination certification, as just has been mentioned, coincidentally, I was speaking at Yale University last week in the context of COVID passports and issues related to COVID-19 certification. I'd be very happy to share the link because we did discuss the EU and also global perspectives in terms of certification. Very, very, very simply, there are still a number of issues which have been alluded to, not only in terms of practical challenges of access. I know that there's very, very different levels of access to vaccines right across the European Union, but also ongoing epidemiological concerns, of which I'm completely unqualified to talk about, but essentially the possibility that vaccines will prevent disease, but they won't necessarily prevent infection, and how to manage those kind of practical challenges. Those, however, are not at all bars to certification. The concerns that I think that this question is going to is discrimination. One of the realities that we're seeing across the world, but also still within the European Union, is the lack of access not only to education, not only to health services, but also to vaccines in vulnerable and minority communities. Especially in minority ethnic communities, we see a very, very high prevalence of vaccine hesitancy, so unwillingness to get a vaccine, which will inevitably cause negative consequences in terms of then access to the certification, access to movement. It may, as I think Álvaro was alluding to, not excludes the liberties that we would expect as EU citizens. For example, it may simply require quarantining, it may require tests, but that still I do recognize is a bar on very fundamental freedoms of the European Union. Another concern that I would just very briefly also raise in the context of this is potential erosion of privacy. I know the Commission is doing a lot in the context of protecting privacy, protecting data that is necessary in any kind of certification. But when we start looking at this globally, when we start looking at it in terms of provision of commercial services, education services, if it gets there, this is going to be a very key question. And again, I would say the Commission is going to be playing a very key role in that protection of privacy. Very briefly, just in terms of my own remarks as how to move forward in the context of vaccination, especially in COVID certification, it's two things. It is access and it is solidarity. Access not only to vaccines, especially vulnerable communities, especially ensuring that we improve access to information, to education, and also to the possibility of resolutions in that context, but also solidarity. When we talk about solidarity, it is a fundamental value of the European Union, but it's also to ensure that we do not ingrain privilege, that solidarity is the value that should guide us throughout the European Union forwards, not only in terms of tackling the pandemic, but seeing our legal systems, reforming our legal systems, and ensuring we all have the best access to the best healthcare possible, especially within the context of such a global ongoing health emergency. As a final pitch, because I was invited to, I am delighted to say we will have a series of 5 webinars over the course of Wednesday to Friday next week. These are inviting country representatives and also commentators from the 2021 Power in the COVID-19 Pandemic Symposium to talk about 5 transversal issues: human rights, democracy, science and decision-making, the rule of law. And the final panel is going to be a series of fantastic commentaries, and also me, but I won't put myself into the fantastic commentary category, which is saying, well, what next? Quo vadis? Where do we go from here? What is the impact of extended emergency? I will again very briefly pop the link into the chat box, but we are opening today for any registrations. You're all very, very welcome to join us. As a very, very final point from me, I just want to emphasize again the privilege it has been to work with the 35 national experts who contributed to this report. We could not have done the kind of analysis and research that we have done without their support, but also the sheer joy it has been working with Democracy Reporting International. They produced incredible work, and if I can recommend nothing else, it's to go to their website now and read their earlier reports on rule of law stress testing in the pandemic. Thank you, Paul, over to you.
Thank you very much to our 2 panelists that are still remaining with us, to Veronika, to Joelle, and of course to Álvaro that had to depart to another meeting. Thank you to all of you who have joined us today. It is very much appreciated. Thank you very much to our donor, Stiftung Mercator, that is funding this critical work across the EU. And of course, indeed, to the experts that have committed time and effort to contribute to this critical report. We encourage all of you to read this report, engage with it, use it in your work, and also please do fill in the evaluation at the end of this event, which is currently in the chat. That will also be coming to your email. Maybe a final word: stay safe, everyone. It is troubling times, and may you and your loved ones and those that you care about be well. All the best, and until next time. Bye-bye.